Hello students, welcome to lesson number 14 on Industrial Dispute Act 1947. The introduction for the lesson. The Industrial Dispute Act 1947, which was agreeable to both employers and employees while keeping the majority of the provisions of the Trade Dispute Act 1929, was based on the experiences of the Trade Dispute Act 1929 and the utility of Rule 81A of the Defence of India rules. By using a certain set of processes and tools for the investigation and resolution of labour disputes, this legislation aims to maintain industrial peace. Its fundamental goal is to ensure that problems are resolved justly and equitably by talks, conciliation, dedication, voluntary arbitration and adjudication rather than through a test of strength through strikes and lockouts. States like Uttar Pradesh, Madhya Pradesh, Gujarat and Maharashtra have their own legislation for resolving disputes in their respective states because state governments are permitted to create their own labour laws. The Uttar Pradesh Industrial Distribution Act is the name of the law, but other countries use the term Industrial Relations Act, which is roughly equivalent to the Bombay Industrial Relation Act 1946. Now the objectives of this lesson. After going through this lesson, the students will be able to understand the principal objectives of this act, the scope, coverage and important concepts regarding industrial disputes and the role of authorities under the act. Now, let us look at the definition of Industrial Dispute Act 1947. As per section 2K of Industrial Disputes Act 1947, industrial dispute is defined as any dispute or difference between employers and employers or between employers and workmen or between workmen and workmen, which is connected with the employment or non-employment or the terms employment or with the conditions of labour of any person. Now, what is the Indian Industrial Dispute Act of 1947? The Industrial Dispute Act of 1947 has been described as the latest milestone in the industrial development in India. The Act has seen new additions in the past few years. However, the principal objective of the Industrial Dispute Act of 1947 are: first one, to promote measures establishing cordial industrial relations between employee and employers. Second, to minimize the differences and solve the disputes through settlement machineries. Third, to provide a suitable machinery for investigation and find settlement for industrial disputes. Fourth, to prevent illegal strikes and lockouts by employee and employers. Fifth, to establish rules and regulations to provide relief to workmen for layoffs and retrenchments. Sixth, to set guidelines for fair labour practices, and seventh, to promote collective bargaining. And the new Indian Industrial Dispute Act principles are as follows, and they are: a permanent conciliation committee for the speedy settlement of industrial disputes. Second, compulsory arbitration in public utility services and enforcement of arbitration awards. Third, it includes strikes during proceedings of conciliation and arbitration meetings are prohibited. Fourth, set aside specific time for conciliation and arbitration meetings. Fifth, employers have to be obliged to communicate with labour unions. Sixth, mutual consultation has to be set up. between industry and labour by the Works Committee. And seventh, disputes between labour and industry have to be forwarded to an industrial tribunal. If the industrial tribunal fails to handle the case, so the case should be forwarded to the appropriate government. Now, let us look at the features of the Industrial Dispute Act, and they are that this act extends to the whole of India, including the state of Jammu and Kashmir. It encourages arbitration over the disputes between employers and employees. It also provides for setting up a works committee as machinery for mutual consultation between employers and employees to promote cordial relationship, and this act paved the way for setting the permanent conciliation machinery at various stages, having definite time limits for conciliation and arbitration. This act also emphasizes on compulsory adjudication besides conciliation and voluntary arbitration of industrial dispute. The act empowered the government to make reference of the dispute to an appropriate authority, that is the labour court, industrial tribunal and national tribunal, depending upon the nature of the dispute, either on its own or on the request of the parties. The right to strike by the workers and lockout by the employees has been subjected to the restriction as laid down in the Act. This Act prohibits strikes and lockouts during the pending of conciliation and arbitration proceedings and in public utility service, and it empowers government to take adequate action. Now, let us look at the scope and coverage of this Act. The Industrial Dispute Act 1947 extends to the whole of India and is applicable to all industrial establishments employing one or more workmen. It covers all employees, both technical and non-technical, and also supervisors drawing salaries and wages up to rupees 1600 per month. It excludes persons employed in managerial and administrative capacities and workmen subject to Army Act, Navy Act, Air Force Act, and those engaged in police, prison and civil services of the government. As regards disputes, it covers only collective disputes or disputes supported by trade unions or by substantial number of workers, and also industrial disputes relating to termination of service. For purpose of this Act, the term dispute is defined as dispute or difference between employers and employees which is connected with the employment and non-employment or the terms of employment or with the conditions of labour of any person according to section 2K. Section 2A defining appropriate government states inter alia, that is the first one, in relation to any industrial disputes concerning any industry carried on by or under the authority of central government or by a railway or concerning any such control industry such as may be specified or linking or insurance company or oil field or major part the central government, and B in relation to other industrial disputes the state government. In HEC Mazdoor Union versus State of Bihar, Supreme Court 1969, it was held that in respect of central public sector undertaking, the state where the factory was situated was the appropriate government. This decision was changed in Air India case in 1997, where it was held that in respect of central public undertakings, the appropriate government is the central government. So, this definition of appropriate government is applicable to Contract Labour Act 1970 and Payment of Bonus Act 1965. The term industry includes not only manufacturing and commercial establishments, but Also professionals like that of the lawyers, medical practitioners, accountants, architects, etc. Clubs, educational institutions like universities, cooperatives, research institutions, charitable projects and other kindred adventures, if they are being carried on as a systematic activity organized by cooperation between employers and employees for the production and or distribution of goods and services calculated to satisfy human wants and wishes. It also includes welfare activities or economic adventures or projects undertaken by the government or statutory bodies and government departments who are discharging sovereign functions. If there are units which are industries which are substantially severable units. And section 2S defines workman as any person including an apprentice employed in any industry to do any skilled, unskilled, manual, supervisory, operational, technical or clerical work for hire or reward. Whether terms of employment be expressed or employed and for the purposes of any proceedings under this Act in relation to an industrial dispute includes any such person who has been dismissed, discharged, retrenched in connection with or as a consequences of that dispute or whose dismissal, discharge or retrenchment has led to that dispute, but does not include any such person, that is, who is subject to Air Force Act, Army Act or Navy Act, or who is employed in police service or prison service, or who is employed mainly in a managerial and advisory capacity, or who being employed in supervisory capacity draws wages exceeding rupees 1600 and exercises by the nature of the duties attached to the office or by means of power vested in him functions mainly of a managerial nature. There is a case called as a May and Baker India case 1976, which led to passing of Sales Promotion Employees Act 1976, has been stipulated that sales or the medical representatives are not workmen. Under section 2S of ID Act, the provision of ID Act 1947 will be applicable to certain class of working journalists as per section 3 of Working